Let's now look at this. The DA will use the supreme law of the land to narrowly challenge, the validity of the recently signed Expropriation Act. The recently signed piece of legislation seeks to, among other things, guide expropriation in the country and meet the constitutional demand of redress. The DA, who has opposed the act from the day it was introduced as a bill, wants it nullified in its entirety. SABC News senior reporter Canny Maphanga unpacks the DA case for us, as stated in the papers. Joining us here in studio, Kenny, the DA from day one has always been against the issue of expropriation, even while it was still a bill in Parliament. Let's look at whether or not does this court challenge delve into this debate.
Well, good afternoon to you, Bongiwe, and to the viewers at home. It's been some time since we saw the President put that pen to paper on the then bill, which we now understand to be the Expropriation Act. Of course, it's important to note that it is an amendment of legislation that already existed. And it is part of the constitutional project where legislation doesn't meet that constitutional demand to achieve redress to affect those remedies. So essentially, that is what the Expropriation Act is about, to guide expropriation for the purposes of public interest or for public purpose. Of course, the DA has been against this bill for some time, and following that signing of the Expropriation Act into law, we're now seeing the DA bring that constitutional challenge, quite a narrow constitutional challenge to that particular act. But of course, it'll give us the opportunity to test the constitutionality of the act rather quite early, as the implementation is set to follow from the minister since the signing. Now,
when you look at the DA's affidavit, they're raising two grounds for their challenge. Let's talk about those ones.
Well, the conversation from the DA has always been about this contentious debate around land expropriation without compensation. It's quite a emotional debate in the country. However, in this particular application, they have shied away from that element. We know that the Act does deal with no compensation, although quite vague. That option is there in the Act. The DA, however, has chosen to focus on two areas that are void of that debate, looking at the procedure, if I could put it that way. They say is constitutionally flawed, leading up to the bill being voted for in Parliament, and then, of course, the subsequent passing of that bill. And of course, they're looking at Section 19, those clauses and the contradictions that may create ambiguity for the various parties where there is a dispute in the expropriation process, and what exactly must take place, because the guidelines are not clear where there is a dispute, what must then follow. Is the notice of expropriation, does it come first, or can you head to the court after the notice is given? So that clarity would be needed in Section 19 as well.
And you then, of course, are looking at the other issue that they speak about, which is the second issue of the procedure.
Yes.
In Parliament. And one wonders why now?
Yes, so the DA has highlighted or has poked holes in the procedure with respect to the mandates given to those provincial delegations when they go and vote on behalf of those provinces. They argue that only two of those provinces had a valid vote. They argued that there wasn't any sittings. For example, in Limpopo, they state that a speaker can unilaterally confer that authority on the delegation without there being a sitting in the plenary for that to be discussed. So they've identified 4 provincial legislatures where they argue, or will argue, in the Western Cape High Court that there is flaws there, and on that purpose alone, or that premise alone, that invalidates the process of the provincial legislators' participation in the passing of the then bill. And of course, they will use that to try and argue that it is inconsistent with the Constitution and must be declared invalid.
It's quite interesting when you look at their papers, The respondent would have been the implementing minister, the Minister of Public Works, and he's a DA, minister. This And when you listen to his tone as well, it does tell you which direction he's leaning towards. So how does this then play out?
Yeah, it's a difficult scenario that you're dealing with now, because it's the first time where we're having a government which composes of multiple different political parties that we know have had opposing views on various contentious issues that have been placed in the landscape and in Parliament as well. And the legislation, of course, is not removed from that aspect as well. We know that the DA has opposed this particular then bill that is now an act, and we know that the first respondent is the Minister of Public Works and Infrastructure, which must implement the act. I mean, no one looks at which political party you are at. You are the minister. The president has signed off on it, and you have obligations and duties with respect to the implementation of that act. But of course, we saw just minutes after that there was a tweet by the Minister of Public Works and Infrastructure, who maintained a stance that there would be no expropriation of private property on his watch. So it'll be interesting to see if when this matter goes to court, if he'll be opposing, if he'll be abiding, if he will submit an affidavit that is in agreement with some of the DA submissions. We'll have to see when that plays out in court. But that is essentially the implementing agent, if you could put it that way. And there is now this constitutional challenge by the Democratic Alliance, the party which he belongs to, and he's cited as the first respondent in this application that will play out soon in the Western Cape High Court.